Good morning, members of the media, our listening and viewing audience on the social media platforms through Facebook and other social media platforms. We welcome you to this morning's press briefing held under the auspices of the Opposition Leader's Office. I am Saddam Hussein, the Member of Parliament for Barataria Sanwan, and with me this morning is Mr. Dinesh Rambali, attorney at law and the Member of Parliament for the constituency of Shogunas West. This morning, we would like to speak to you, the members of the media, and the listening public about some of the grave injustices and some of the dangers to our democracy in relation to the police service and also other independent institutions under the Constitution. So, the order of the program will be this morning is that Mr. Rambali, I will hand over to him in order to make his presentation, and then I will make my presentation, and then we will take questions from members of the media. Mr. Rambali.
Thank you, MP Saddam Hussein. Good morning to Trinidad and Tobago. I too would like to join, of course, my colleague, MP Saddam Hussein, attorney at law and Member of Parliament for Barataria Sanwan. I would like to join him on behalf of our Honourable Leader of the Opposition, Mrs. Kamala Persad-Bissessar, Senior Counsel, and my parliamentary colleagues. We would be speaking this morning. I welcome all of you, citizens, and of course members of the media, to this press conference. Our press conference this morning surrounds the topic how Keith Rowley dismantled the police service. Now, I don't think that it can be disputed. Trinidad and Tobago is presently beleaguered by a constitutional crisis as a result of the actions of high office holders in the personalities of the Prime Minister, Dr. Keith Christopher Rowley, former chairman of the Police Service Commission, Ms. Bliss C. Persad, and the President, Her Excellency, Ms. Paula May Weeks. I would like to just, undertake a brief recap of some of the events which led us to today's date and this ongoing constitutional crisis. We all know that the Police Service Commission prepared a list of candidates for the post of Commissioner of Police in order of priority, which was submitted to the Office of the President. The list was withdrawn almost immediately thereafter, and according to the President, and therefore she did not have a list from which a notification could be issued to the Parliament. Her Excellency has sought to make clear the limits on her power, indicating that the President is a creature of statute. Yet she has failed to say on what statutory basis she allowed a list to be recalled or withdrawn or taken back or whatever you want to call it, and thereby failed in her statutory duty of passing it on to Parliament. All the fancy legal language will not fool the people. She obviously held it back upon some kind of advice proffered to her. So why was the merit list withdrawn with such haste? Well, it is now no secret that the Prime Minister had a word with Ms. C. Persad, or as he put it, he passed on some pertinent information to her. You may ask, what is wrong with this? Well, everything is wrong with this. That might be the surface picture, but what lurks beneath is a festering wound that has the potential to inflict severe damage to our democracy. The Prime Minister had no right in law to interfere with the deliberations and decisions of the Police Service Commission. He has admitted his prejudice against certain members of the then Police Service, and clearly he had the misplaced notion that he could act on it until certain compositions within it are to his liking. I would like to reference what is really a police state. The reason why no civilized country wants to have their political leaders effectively in charge of the police service is because nobody wants a police state. Let me define what is a police state according to the Britannica Dictionary. A country in which the activities of the people are strictly controlled by the government with the help of a police force. North Korea has some characteristics of a police state. No democratic country wants to get there. And certainly we in Trinidad and Tobago do not want to go there. For that reason, the government and the police service are two distinct entities. The police ought not to take instructions from the government. This is why our constitution insists on the independence of the Police Service Commission. It is the only way that the rule of law can be preserved. And I will get to the importance of rule of law in a bit. You see, independence of certain entities and commissions is paramount. No outsider, be it government, pressure groups, or individuals should interfere or even attempt to interfere with the way the Commission conducts its business, including how it makes its decisions. Influence and suasion are simply not permitted. Our Constitution has checks and balances for ensuring the proper balance between organs of government and the various service commissions in our constitutional system for the purpose of ensuring that the rule of law is upheld. And on the rule of law, this is a foundational concept in constitutional law. It is properly invoked by aggrieved citizens to challenge any perceived unfairness at the hands of the government. For the purposes of our discussion this morning, I will say that the rule of law means that 1. The law of the land is supreme over the acts of government and its officials as well as private persons. That is, no one is above the law. 2. The rule of law requires the existence and maintenance of a positive legal order, which provides and preserves the normative order for our society. And 3. The exercise of all public power must find its ultimate source in some legal rule. The rule of law encompasses a sense of orderliness, of subjection to known legal rules, and of executive accountability to legal authority. At its most basic level, the rule of law vouchsafes to the citizens a predictable and ordered society in which to conduct their affairs. So it provides a shield for individuals from arbitrary action by the government. Now, the modern doctrine of police independence is generally traced to a 1968 British common law case. My colleague MP Saddam Hussein, an attorney who practices alongside myself before the courts. We all know the case of Arran Police Commissioner of the Metropolis ex parte Blackburn, in which Lord Denning concluded that the Commissioner of the London Police, like every constable in the land, was and should be independent of the executive. He is not the servant of anyone, save of the law itself. So no minister of the crown can tell him that he must or must not keep observation on this place or that he must or must not prosecute this man or that one. Nor can any police authority tell him so. So the responsibility for law enforcement lies on him. He is answerable to the law and to the law alone. And this, ladies and gentlemen, is one of the reasons why we have to be worried. This issue concerns how a prime minister set about to break the law because he believes the law does not apply to him. And this is a dangerous precedent by any stretch of the imagination. Without the rule of law being preserved, what prevents the Prime Minister, Dr. Rowley, from accusing anyone of serious wrongdoing and demanding they be fired or removed from their post while hiding behind a secret report which only he has access to? Having no substantive commissioner of police leaves the Trinidad and Tobago Police to date rudderless and under the control of Rowley's hand-picked acting commissioner of police. This is a clear undermining of the Trinidad and Tobago Police Service, which our Constitution has so carefully guarded against, and which we, going forward, we must guard against. When we get to interference, the former Commissioner of Police is on record as saying that the Prime Minister, Dr. Rowley, got upset with him when he, Gary Griffith, refused to take instructions concerning locking up certain political opponents of the PNM. That is interference, and the Prime Minister knows it. The Prime Minister was careful to say that in his meeting with Ms. Bliss Sipasad, former chairman of the Police Service Commission, that he only provided her with pertinent information. He did not interfere. Ladies and gentlemen, this is the information age. Nobody goes to physically meet with someone to merely give information, especially not in a pandemic. People could email, they can fax, they can telephone, WhatsApp, all kinds of different things. But who gets to meet in President's house without the President's knowing? Nobody. Therefore, the President has some questions to answer too. Did she facilitate such a meeting? Did she know of the nature of the meeting? Did she approve the objective of the meeting? If yes to any of these questions, on what statutory basis did she as President do so? After all, she has made it clear that she as President is a creature of statute, and everything done by her must be derived by the authority of some law. Yet, the Prime Minister saw it fit to go in person and deliver pertinent information to the chairman of the Police Service Commission. We, all of us, would be taken for fools if the Prime Minister would have us believe that no conversation and exchange of ideas took place between these two high office holders. Surely this didn't happen like the movies, where one character carrying the briefcase and merely puts it down and continues walking away while the other just picks it up and moves off in the opposite direction. In fact, the meeting at the President's house was so out of the ordinary that there must have been some explanation by way of context by the Prime Minister to the then chairman of the Police Service Commission, Bliss Sipasad, as to why it was happening at all. So in essence, an extraordinary meeting took place to subvert a lawful process, and one which threatened to capsize the independence of the commissions. So by his own admission, Dr. Rowley has said he has had problems with Gary Griffith. And according to Griffith, the Prime Minister's problem with him was that he, Gary, refused to take instructions from the Prime Minister to hire foreign lawyers to go after members of the UNC or the political opponents of the PNM. Is that not high-ranking, self-serving, political expediency on the part of the Prime Minister, Dr. Rowley? There are other reasons, we are told, as to why the Prime Minister thought of Gary as a huge disappointment, but we will not get into that right now. Now, after the meeting, the merit list was intercepted so that Gary's name could be effectively removed. The deal was done, and the Prime Minister got his way. The Prime Minister thought he could pull the wool over the eyes of our people. But I want to tell him, our people are smarter than you give them credit for. Soon enough, people began asking questions and would not let it rest. Who was that high-ranking official that intercepted the merit list? Did this magic mischief managed and made Gary's name disappear? Mrs. Prasad Bisesa, as leader of the opposition, led a relentless pursuit of the truth, both in and out of the parliament. Prime Minister Rowley, the former chairman Bliss Sipasad, and Her Excellency Madam President all forgot their duty of candor as public officers holding public office. Well, the country waited and speculated, yet we all knew deep down. But then months later, the Prime Minister confirms and confesses that it was he. Now, just to make sure that all of us are on the same page, the journey of that merit list would be as follows. It is handed over to the President by the Chairman of the Police Service Commission. And then it is submitted by the President to the Parliament. It is here in the Parliament that it would have formally reached the attention of the Prime Minister. It is here in the Parliament that the Prime Minister could have considered and acted on the list before him. It is anyone's guess on what pretext the Prime Minister asked to see the merit list. Did he use his rank and power as Prime Minister to exert unspoken pressure on persons to show it to him? Could he not have waited until it reached the Parliament, as it would have anyway? It is in the Parliament that the Prime Minister had an effective veto power to say, no, we don't want Gary or whoever, and it would have to be subject to debate. It is here that the Prime Minister could have rejected his candidacy. The Prime Minister received a merit list before in the Parliament, and if you recall, chose Gary Griffith some years ago to be the Commissioner of Police. So now, it begs the question, why veto the top applicant by causing the merit list to be withdrawn in a manner that reeks of secrets, half-truths, and conspiracy? Why? We demand to know. What has transpired in this fiasco is not simply how a Prime Minister wanted to arrogantly get rid of a police commissioner out of a personal vendetta. This was an assault on the independence of the office of the Commissioner of Police. This was an attack on our constitutional democracy. It is the same government which amended the law to have Gary appointed. They do that, you know, tweak and fix and interpret laws and end up in court for assistance with interpretations. Former Attorney General, now former Attorney General Faris Al-Rawi had the bold-facedness to go before the court and somehow limping along, wanting to get an interpretation and joining, you know, when the interpretation was brought, joining other arguments. Maybe they wanted a deputy, not necessarily a Commissioner of Police, who sings to the tune of the Minister of National Security, someone who would sit alongside and flank the incompetent Minister of National Security at all public appearances and national security press conferences. You know, they're so chummy, they can finish each other's sentences. You call that independence? But it's important to get back to the travesty of interference and malfeasance in public office. Mr. Prime Minister, the country needs to know, did you at any time, in addition to providing pertinent information, give a suggestion or two on what is to be done with such information? If yes, that is interference. Mr. Prime Minister, please tell the country, did you at any time, in addition to providing pertinent information, give an opinion on what should be done with that pertinent information? If the answer to that is yes, that is interference. Mr. Prime Minister, you must tell this nation, did you at any time, in addition to providing pertinent information, give an insinuation, a hint, or intimation on how that information should be acted upon? If the answer is yes, that is interference. Mr. Prime Minister, you must tell this nation, how did you know that Gary's name was at the top of the list as the top contender for the post of police commissioner? Did you ask to see the list? And if so, did you express your disappointment on the fact that he was a top contender? If so, that is interference. Now, as I seek to conclude, I want to say, how is it that we have laws that would hold Dr. Rowley to account, and we have something called misfeasance in public office? Ladies and gentlemen, as the dust settles, we must ask, did Prime Minister Rowley, the holder of a top public office, deliberately engage in unlawful conduct while exercising a public function? Did he appreciate that his conduct was likely to cause injury to the then Commissioner of Police and or persons named on that merit list? Just as a fiduciary cannot make decisions out of self-interest, neither can a public officer exercise discretion in a way that promotes his own personal ends. The actions surrounding the inference with the merit list has all the elements of misfeasance, or sometimes it is called malfeasance. Only time will tell if any action is brought against him under this tort based on the fact that he has misused or abused his power. I would also want to touch on misbehavior and misconduct in public office. Dr. Rowley, Ms. Bliss Sipasad, and the President, Her Excellency Ms. Paula May Weeks, have acted in a manner which under law can amount to a conspiracy to undermine clear provisions of our Constitution, abuse their positions and office, and subvert the proper functioning of the Police Service Commission. In the interest of time, I merely repeat the calls made by the Honorable Leader of the Opposition and some of my parliamentary colleagues that these are matters which must be investigated by the police service and take the appropriate advice, if necessary, from the Director of Public Prosecutions. Now, I want to talk about what is the duty to investigate, because it seems as though our Commissioner of Police, somehow or the other, he's not up to the task. Acting Commissioner of Police McDonald Jacob was referenced in a 17th March 2022 TV6 News article by Renessa Cutting as responding to questions posed to him by media on whether the Trinidad and Tobago Police Service will be investigating claims of interference in the process of the selection of Top Cop. Jacobs apparently said that it was already investigated. Special Branch would have investigated when the allegations were first made, but said that the person making the allegations did not cooperate. It would be prudent for the acting commissioner to take some advice if necessary, as he does not seem to appreciate that the police service has a duty to investigate in light of the admission of Prime Minister Dr. Rowley that he did in fact intercept the merit list. Immediate action must also be taken by the Integrity Commission. You see, under Section 37 of the Integrity in Public Life Act, Chapter 2201, the Commission may on its own initiative consider any matter with respect to the duty or obligation of a person under the Act, where in the Commission's opinion, it is in the public interest to do so. It is certainly in the public interest to consider whether any breaches of the Integrity in Public Life Act have occurred, having regard to the Prime Minister's admission that it was he who interfered with the merit list alongside former Chairman Bliss Sipasad and President Paula May Weeks. Under Section 24, a person in public office shall be fair and impartial in exercising his public duty. Under the Section 24 of the Integrity in Public Life Act, it says that a person in public office like Dr. Rowley shall afford no undue preferential treatment to any group or individual. He shall not arrange his private interests, whether pecuniary or otherwise, in such a manner as to maintain public confidence and trust in his integrity. A person whom the Integrity in Public Life Act applies shall not use his office for the improper advancement of his own or his family's personal or financial interests or the interests of any person, and engage in any transaction whatsoever, acquire any position, or have any commercial or other interest that is incompatible with his office, function, and duty or the discharge thereof. Under Section 25, a person in public office shall not use information that is gained in the execution of his office and which is not available to the general public to further or seek to further his private interests. And what is critical in the Integrity in Public Life Act as well is that under Section 26, a person, and in this case we are talking about the Prime Minister, Dr. Keith Rowley, a person shall not use his office to seek to influence a decision made by another person or public body to further his own private interests. It is critical, and so I call on the Integrity Commission as well to get down to work and to start investigating these matters as well, in addition to the police service, and we must get some answers. We have to hold Dr. Rowley to account, else his office, he is bringing that esteemed office of the Prime Minister that, into one of odium and disrepute. Ladies and gentlemen, all roads lead to the same conclusion. Prime Minister Dr. Rowley must subject himself to an investigation. If he cannot show that his conduct has been above reproach, which he cannot do, we say he cannot do it, or that he has acted within the remit of the law, which he cannot do, or that his personal prejudices and interests did not influence his actions, which he cannot do, then he must be asked to step down with immediate effect. After all, the last time I checked in Trinidad and Tobago, no one is above the law, not even Dr. Keith Christopher Rowley. In this constitutional crisis, there is a clear and present danger that the upper echelons of the police service is fast becoming a political party group of the PNM and Dr. Rowley. Ladies and gentlemen, we will of course take any questions from members of the media after. I would like to thank you all, and I would like to thank MP Saddam Hussein. I would now hand over back to Member of Parliament for Barataria Sanwan, my distinguished colleague, MP Saddam Hussein. Thank you.
Thank you very much, MP Rambali, for that very comprehensive report and review over the entire debacle relating to the collapse of the Police Service Commission and the interference with the merit list. I just want to join issue also with MP Rambali regarding this issue in terms of just zeroing down a little more in terms of the facts of what took place that day at the President's house. Now, we learned that on the 11th of August 2021, a substantive merit list was in fact submitted to Her Excellency by the Police Service Commission, indicating that these are the four persons in the order of merit to be appointed as Commissioner of Police. First was Gary Griffith, second was Jason Francis, the third was Andrew Norton, and the fourth was Erla Harewood Christopher. Now, on that day that MP Rambali spoke about, the 11th of August 2021, the President, by her statement that she issued to the media, many of you would have had the statement that the President would have issued. This statement contained some information from the President, and I quote from the President that I confirm that an order of merit list in respect of the Commissioner of Police was delivered on August 11th, 2021 to the OTP, Office of the President, and withdrawn almost immediately thereafter that day. So it meant that Ms. Bliss Sipersad did in fact hand the list over to Her Excellency Paula May Weeks. And we would have learned from leaks that came out of the Police Service Commission that was reported widely that a high-ranking official would have in fact had a discussion with Ms. Bliss Sipersad, which caused her to excite her suspicion to withdraw that merit list for the substantive appointment of a Commissioner of Police. And then nobody knew who the public official was. In fact, the President in her statement said that it is none of our business for her to disclose who meets with her at the President's house. Ms. Bliss Sipersad did not disclose the identity of the public official. It was after the Paria incident, the Prime Minister, so desperately looking for a distraction, disclosed that he was the high-ranking public official who met with Ms. Bliss Sipersad that day at the President's house. Now, what does this mean? MP Rambali went through very thoroughly what will amount to an interference. The information that the Prime Minister would have submitted or given to Ms. Bliss Sipersad was so much so that it caused her to pull back the list on the 11th of August 2021, and then on the 12th of August 2021 submitted a list for the acting appointment of Commissioner of Police. Now that is important, because the Prime Minister would have indicated that there are security concerns in relation to a particular candidate. And therefore, we saw that exact same candidate appearing as number one on the acting list. who was then appointed as the acting commissioner on the 17th of August 2021. So one now has to ask the questions because we have to get down to the facts. We have to drill into the facts of what took place on that day. How did the Prime Minister know that Ms. Bliss Sipasad was about to deliver the list to the President on the 11th of August 2021? Did the Prime Minister have knowledge beforehand that Mr. Gary Griffith was on top of that list? Or did the Prime Minister get that information after the list was submitted to Her Excellency and thereafter then met with Ms. Bliss Sipasad and provided the necessary information? Now that is absolutely incorrect in the manner in which it was done, because the Prime Minister admitted that he would have written to the Police Service Commission in the past in order to make complaints about the former Commissioner of Police. In fact, there was a letter dated September 2020 when the Prime Minister had indicated he had lost confidence in the Commissioner of Police, that he had to write to the Police Service Commission. But is it that the Police Service Commission ignored that letter and still, after the assessment, made Mr. Griffith ranked number 1 on the list? And thereafter, the Prime Minister then went to the President House to provide information that caused that list to be withdrawn. So one has to ask now, how did the Prime Minister know that that was the business that Ms. Sipasad was going to conduct on that day? How did the Prime Minister know what time she would have been at President's House? How was the Prime Minister invited to also attend that particular meeting with Ms. Bliss Sipasad by President? These are some of the pertinent questions that we have to ask. And then when this matter broke in the public, the President did not disclose that it was the Prime Minister who was the high-ranking official. The Prime Minister had several press conferences and did not disclose that he was the high-ranking public official. Ms. Bliss Sipasad remained silent and she didn't disclose who the high-ranking official was. Now the Prime Minister has admitted that it was him. What we have seen now is a conspiracy. It is a web. It is complete deceit in terms of the manner in which this was done. The Prime Minister ought to have followed the constitutional procedure whereby after the list was delivered to the Her Excellency would then send a notification to the Parliament. And the Prime Minister, he had the power, he has the majority in the Parliament to say, well, we don't want this particular candidate. Let another notification come with the second, third, or fourth candidate. The Prime Minister had no power in order to go to the President's House in order to deliver that type of information. Why was not it reduced into writing and sent as a formal complaint to the Police Service Commission? One has to answer these questions. And this is not only the Prime Minister has to answer, but the President and Ms. Bliss Sipasad, because it is about time. Press conferences and press releases are no longer going to absolve you. It is time that the police gets involved in order to properly investigate this matter, and people have to now answer to the courts of law in Trinidad and Tobago regarding this matter. And people will think this is a matter about Gary Griffith. This is not about Gary Griffith. This is about attacks on independent institutions in Trinidad and Tobago, which has the ability to undermine our democracy and, as MP Rambali said, turn Trinidad and Tobago into a police state. So those are the issues that we as the opposition want to address. How did the Prime Minister know the business to be conducted that day at the President's House, that he had to appear there at that same time together with the Chairman of the Police Service Commission? Normally when there are engagements at President's House, there will be an agenda and each person will be given a specified time in which they arrive. Was it that the Prime Minister got the exact same arrival time as the former disgraced Chairman of the Police Service Commission, Ms. Bliss Sipasad? And that what is even more strange is that the Prime Minister admitted that he lost confidence in Gary Griffith around September 2020. So let's follow the time. In September 2020, the Prime Minister indicated that he lost confidence in Mr. Griffith. In August 2021, Mr. Griffith's contract would have expired as Commissioner of Police. But before his contract expired, a legal notice changing the law in terms of the selection procedure for the Commissioner of Police was laid in the Parliament June 2021. And that piece of law was an ad hominem piece of legislation. It was a law designed for Mr. Gary Griffith to be appointed as the acting Commissioner of Police in the event that the Police Service Commission was not able to complete the appointment list for the substantive Commissioner of Police. So the Prime Minister, as the head of the Cabinet, would have approved a legal notice changing the law for Mr. Gary Griffith to act in the position as the Commissioner of Police, because the law at the time did not allow him to do so when his contract would have expired. So after you lost confidence in him in September 2020, why did you now come in June 2021 to approve a law that allows him to act? It simply does not make sense. Prime Minister, you have to make it make sense. Is it that, as we have learned this morning in the newspaper, the Express newspaper, that legal notice was brought without the approval of the Cabinet or the Prime Minister? Because we have seen now, and I will address that soon, instances where we have now learned that various bills would have been, or instructions being given to public officials where Cabinet approval or the Prime Minister's approval was not sought. Is it that after that particular law was passed, I'm asking that the Prime Minister had to attend the President's House on that day to provide information so that a particular name doesn't go forward to the Parliament? Is it that is why that the Prime Minister had to go on President's House that day, because he was set up with this legal notice 183 of 2021 that was eventually partly struck down by the courts, that led to the collapse of the Police Service Commission, that also led to a constitutional crisis whereby a Commissioner of Police was not in place in Trinidad and Tobago? So I'm asking these questions, and these are pertinent questions that we need to ask. Now, I indicated that I will be addressing another issue this morning that came to our attention. It was quite a frightening issue. And I think we have now learned, the country has now learned, of the real reason why Faris Al-Rawi may have been fired as Attorney General from the Cabinet. This morning, this is the Express front page. Faris's last act, Sunday Express. On the day of Cabinet reshuffle, wrote to CJ Archie requesting his right hand legal ban be suspended for insubordination. So let's deal with this particular issue. Under the Constitution, there is a constitutionally protected office that is a special office called the Chief Parliamentary Council. And the Chief Parliamentary Council finds its place in the under the office of the Attorney General. It is an insulated office, independent of the political arm. Therefore, that person is appointed through an independent service commission. What we have learned is that there has been an attempt to undermine the independence of the Chief Parliamentary Council over several matters that took place at the office of the Attorney General and the Ministry of Legal Affairs. So while on Wednesday, Mr. Al-Rawi was trying to get another man suspended and or fired, he himself was fired from the Cabinet. It was his fall from grace, and that was the 16th of March, 2022. So let's look at the procedure in which bills originate and they are brought to the Parliament floor. So before a bill is brought to the Parliament floor, the government must have a policy. So that is the government's plan. The government's policy will now be approved by the Cabinet, and then the Cabinet will then give instructions to the Attorney General that this particular issue needs to be reduced into law. And therefore, the Attorney General will pass that Cabinet instruction onto the Chief Parliamentary Council, which has contained in it the government's policy for the drafting of the particular law. So it is not the business of the Chief Parliamentary Council to get involved in government policy. Because even if the Chief Parliamentary Council agrees or disagrees with government's policy, he has to draft the law. And that is his duty under the law. So what we have seen is the Attorney General is now telling the Chief Parliamentary Council to draft particular pieces of law that did not have the Cabinet approval or the Prime Minister's approval. So there are cases in which there are emergencies in which you may not be able to get the Cabinet approval, but a note has to be sent to the Prime Minister for his particular approval. For example, let's say in this pandemic or states of emergencies. That is understandable. But in this case, the Attorney General is overriding the authority of the Cabinet. He's undermining the authority of the Prime Minister and giving the CPC direct instructions to draft particular laws by his own sole instruction without the necessary approval being granted by the Cabinet or the Prime Minister. So the Attorney General attempted to then bully a sitting Chief Parliamentary Council whose office is protected by law. And what the Attorney General would have done is written to the Chief Justice, who is the chairman of the Judicial and Legal Services Commission, to discipline Mr. McIntyre, because Mr. McIntyre indicated to the Attorney General that he is not obliged to take any instructions from the Attorney General. He takes instruction from the Cabinet in terms of the drafting of laws, and that is his code of ethical conduct and also his duties as outlined in the law. And the Chief Parliamentary Council did in fact send a letter dated the 14th of March 2022, a copy of which I have in my possession, to Mr. Corey Harrison, the Director of Personal Administration, outlining the issues and the political pressures that he was being faced by the former Attorney General, Mr. Faris Al-Rawi. And Mr. Faris Al-Rawi needs to account for his actions in terms of bullying a public official in order to do his bidding. And that is why, as the opposition, we have continuously said that the former Attorney General has been bringing bad laws to the Parliament. We now understand why, because the Attorney General is trying to bypass the office of the Chief Parliamentary Council. And the Chief Parliamentary Council has been trying to give the Attorney General advice, which clearly he has ignored, and therefore end up in having laws that cannot to this day be proclaimed because there's a lack of implementation and a lack of consultation. What we have also seen is that the Attorney General is giving instructions on behalf of other ministers, because ministers will normally carry their policy to the Cabinet for it to be approved and then made into law. What we have seen is that the Attorney General is passing ministries and their policies and drafting laws on his own. And I will get to that particular law in which Mr. McIntyre would have had issues with. Because Mr. McIntyre in his letter did in fact clearly outline the reasons why he is not obliged to take instructions from the Attorney General. It is totally embarrassing. This former Attorney General, I beg your pardon, has acted in a manner that is contrary to law, and in fact he has attempted to be a dictator in that particular ministry, trying to bully a public official. Now, Mr. McIntyre in his letter would have outlined all of the issues in which he would have had in terms of why he's not following the instructions of the Attorney General, because it was inconsistent with his Code of Ethics and the Legal Profession Act. It bypasses the role and responsibilities of ministers, permanent secretaries, chief technical officers, heads of department, and other senior public officials. It institutionally weakens the capacity, capability, and efficiency of government ministries. It deprives the Parliamentary Council of instructing officers of appropriate seniority who are knowledgeable in the matter of the proposed legislation. It unduly involves Parliamentary Council in the process of policy development. That is not the business of the Chief Parliamentary Council. He is not in the business of government policies, he is in the business of drafting laws. It is the government who is in charge of policy, but because of a lack of plan and no policy, we have ended up into this particular scenario. It will lead to legislative gaps, results in lack of due respect and appreciation for the role and function of senior officials. And then Mr. McIntyre, and I quote, which was very frightening, If anyone knows Mr. McIntyre, they will know he's a man of very little and few words. He's senior counsel, or he was appointed as senior counsel. And one, when reading this letter, would have been shocked that this was Mr. McIntyre who drafted it. He said, and I quote from this letter, which is extremely frightening, and I ask the media to pay attention to this particular paragraph. He said the legislative drafting department is merely seeking to perform its function with integrity and professionalism in accordance with a long-established principle of good governance and the standards of the legal profession. My grave concern is that if the coercive behavior of the Attorney General is allowed to go unchecked, the consequences would be disastrous for the legislative drafting department, the public service, and the country as a whole. Those are the words of the Office of the Chief Parliamentary Counsel. That is in fact disturbing to know that the man who was entrusted as the guardian of our Constitution and our democracy, has a public official having to write a letter in this manner condemning his actions at the Ministry of the Office of the Attorney General. And the bill that in fact the Attorney General was attempting to push through the Parliament without the ministries, without the necessary ministries' policy and approval, was in fact an amendment, an agent amendment to the Interception of the Communication Act. Why was the Attorney General the former Attorney General, I beg your pardon, why was the former Attorney General attempting to push through an urgent amendment to the Interception of Communication Act, in which the Chief Parliamentary Counsel had to stop him dead in his tracks, because the Chief Parliamentary Counsel recognized that there was no policy coming out from the Ministry of National Security, and in fact, due to the urgency of the matter, there was no note from the Prime Minister giving any approval for that particular law to have been drafted. So those are the questions in which we have to ask. And then that begs a further question. How many laws has the Attorney General passed in this manner or brought to the Parliament, introduced, that did not have the necessary cabinet approval or the Prime Minister's approval? I sat in the Tobago Joint Select Committee, and when we asked for the government's policy on that particular bill, no policy was presented. We asked again for policy on the Representation of the People Act. No policy was given. We saw the embarrassing piece of proposed legislation that the Attorney General brought, which was the fireworks law, that even his own cabinet colleagues came out in public, Minister Young and Minister Gonzalez, to say that they are not in agreement with that particular law and they are all bound by cabinet responsibility. So therefore, I don't believe that particular law would have had the necessary cabinet approval. Was Legal Notice 183 of 2021 to appoint Mr. Griffith as the Acting Commissioner of Police, did that receive the Prime Minister's approval or cabinet approval? So we have seen, based on these correspondence between Mr. McIntyre and the Service Commission, the JLSC, and also letters between the former Attorney General and Mr. Ivor Archie as chairman of the JLSC, we have seen an Attorney General who has been totally out of control. And he deserved to have been fired for actions like this. And Mr. Al-Rawi should do the honorable thing now and don't take selfies and pose with people up in Grandi on Toko, but tender his resignation as the Minister of Local Government and Rural Development. That is what he has to do. Mr. Al-Rawi has lost his credibility after we have learned what has taken place right now in the Office of the Attorney General to even sit in the cabinet, because you have attempted to undermine protected offices under the law. So I thank you very much, members of the media. If you have any questions, we are open to answer, myself and MP Ramley.
MP Hussain, can you hear me?
Yes.
So we have a question from Rihanna McKenzie from New States, directed to MP Ramley. Can you please review the legal grounds that justify an Integrity Commission inquiry into the matter? If they are legally obliged to investigate, why haven't they done so yet? It is a good question. I want to thank Ms. McKenzie for that question. I am not in a position to answer why they have not done anything yet, meaning why the Integrity Commission has not done anything. I know this confession, this admission of the Prime Minister, this acceptance, after months, many months, at least 8 months of the public inquiring who was that high ranking official that intercepted the merit list at the president's house, who was the one responsible for acting in concert with the former chairman of the Police Service Commission, Ms. Bliss C. Prasad, thereby leading or resulting eventually in the total collapse of the Police Service Commission. I'm talking about the previous incarnation of the Police Service Commission. We finally got that information this last week, so I can't answer why. I don't know if they have their own